one member voted against it, the motion is discarded. I believe that the House is in a position to proceed with the motion. Mr. Speaker, I rise to
Mr. Speaker,
this motion.
on a point of order. Standing order 26. Dealing with admissibility of motions. It says, sir, that in order that a motion may be admissible, it shall satisfy the following conditions. And I wish to refer to condition G, that it shall not relate to any matter which is under adjudication by a court of law. Sir, I have here notice of motion filed in the High Court, numbered 69M of 2012. A motion instituted in the matter of the Constitution of the Republic of Guyana, in the matter of the rules of the High Court, in the matter of the inherent jurisdiction of the High Court, the Attorney General against David Granger in his capacity as leader of the opposition, and Raphael Trotman in his capacity as Speaker of the National Assembly. Respondents jointly and separately. Mr. Speaker, the action itself, if I may be permitted with your kind leave, to read the release. It reads as follows. A declaration that motion moved in the National Assembly on the 25th day of July 2012 by Leader of the Opposition, Brigadier Retired Mr. David Granger, MSS, MP, and duly passed on the 30th day of July 2012, is unlawful, violative of the doctrine of separation of powers, unconstitutional, null, void, and without any binding force or effect, insofar as same purports to censor, as they no confidence in Minister Clement Rohee MP. Then the second relief is a declaration that resolution number 18 passed by the National Assembly on Monday the 30th of July 2012 is unlawful, violative of the doctrine of separation of powers, unconstitutional, null, void, and without any binding force or effect, insofar as same purports to censor and express no confidence in the Minister of Home Affairs, Mr. Clement Rohee. Attached to the motion, sir, is an exhibit AG1. It's the motion which was passed by the National Assembly along with a certificate from the Clerk of the National Assembly, as well as the resolution which resulted from the motion. I refer to the motion now which is before the House. The resolve clause reads as follows, that since the National Assembly, by National Assembly Resolution number 18/2012, the very resolution which is the subject of the court matter, which is that resolution number 18 of 2012 has expressed no confidence in the performance of Honorable Clement Rohee MP as Minister of Home Affairs, that he be prevented from speaking in the National Assembly so long as he's purporting to carry out the functions of Minister of Home Affairs as published in the official gazette. So, sir, the identical subject matter which is the subject of this motion that the leader of the opposition is embarking to speak upon is the identical motion which is the subject of legal challenge. I have, sir, the resolution number 18. This motion, the resolution that it seeks, expressly says that it is resolution number 18 of 2012. And this motion seeks to prevent the minister as a result of resolution number 18. And resolution number 18 is the subject of legal proceedings. And applying Standing Order 26G, it shall not relate to any matter which is under adjudication by a court of law. This matter, which is the subject of the motion, I humbly submit, sir, is clearly in adjudication by a court of law and therefore is prohibited by a standing order. It is inadmissible. Inadmissible. It cannot begin to proceed with the debate. That's my first objection, sir. My second objection is rooted in Article 146 of the Constitution. Your Honor will recall that in Your Honor's ruling, you very carefully articulated, relying and citing on the case of Sabarochi against the Attorney General of the Commonwealth of Dominica, dictum to the effect that the Parliament must always act in conformity with the Constitution. Specifically, in Sabarochi case, it was an attempt to prevent a member from speaking in the National Assembly. And the judges of the OECS Court of Appeal were very, very clear and trenchant in their ruling. They say that the National Assembly has no authority in law or under the standing orders to violate a person's fundamental rights. Minister Rohee, as every other citizen of this country, is conferred by virtue of Article 146 of the Constitution of the Republic of Guyana, the freedom of expression. I will read the article. Except with his own consent, no person shall be hindered in the enjoyment of his freedom of expression, that is to say, freedom to hold opinion without interference, freedom to receive ideas and information without interference, freedom to communicate ideas and information without interference, and freedom from interference with correspondence. Nothing contained in or done under the authority of any law shall be held to be inconsistent with or in contravention of this article to the extent that the law in question make provisions. That is, so these are the exceptions now, where a citizen can lose their freedom of expression. It can only be done in the following circumstances. Under the authority of a law, that's the first thing. We are not operating here under the authority of any law. We are operating here under standing orders, most of which have been suspended in any event. It is strike law that standing orders do not have the force of law. So there is no person, or this assembly is not acting under the authority of any law. Continue. A law that makes provision that is reasonably required in the interest of defense, public safety, public order, public morality, or public health. Public ability. B, that is reasonably required for the purpose of protecting the reputation, rights, and freedoms of people. Of course, they're speaking of libel laws and so on. That has no application. Thirdly, that imposes restriction upon public officer or public officers of any corporate body established on behalf of the public or owned or on behalf of the government of Guyana. That has no application. D, that imposes restriction upon any person, institution, body, authority, or political party from taking any action or advancing or disseminating or supporting any idea which may result in racial or ethnic division among the people of Guyana. That has no application. So, sir, it is my duty to advise this assembly that should this assembly proceed along the route which it is embarking upon, the ineluctable consequence will be the violation of Article 146 of the Constitution, the violation of Minister Clement James Rohee's fundamental right to express itself, and more importantly is that the creature of the Constitution, and I see, sir, the motion itself, which is before the House now, cites several sections of the Constitution seeking to establish the sovereignty of Parliament. But at the beginning of every one of those constitutional provisions, you will see the words subject to the. I have said repeatedly that this Parliament is not above the Constitution. This Parliament was created by the Constitution, and it is a creature of the Constitution. It can only act within the parameters given to it by the Constitution. The Constitution does not authorize. The Constitution does not authorize this Parliament to violate the rights of any citizen. And sir, if this Parliament is proceeding along that course, I am adverting this Parliament's attention, as I am duty bound to do as Attorney General, of the consequences that will go. I thank you very much.